Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live, where I believe we have overcome our technical issues that we had on the pre-show. Apologies to all of you who were there. Let's start with Judge West. Her Monday Parade of Fashion has already begun.
Of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm asked for a court appointment.
Right, so when you're in custody, we automatically give you a court-appointed lawyer, but now that you've made bond, I'm going to expect you to at least try to hire your own lawyer. So I'm going to reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, you're going to get a reset notice today. Bring that to the lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you talk to, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Ronnie Green. Ronnie Green.
No, you can, before you go.
This bond will be forfeited for non-appearance and reset at $100,000. Kelly Blanchette, or Kelby Blanchette. Good morning. Are you Kelby Blanchette? And Mr. Blanchette, this is your initial appearance in cause number 25 DCCR 0799. You're charged with the 3rd-degree felony offense of obstruction or retaliation from May 21st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so I'm going to reset your case, give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you talk to so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Samuel Cadena. Good morning, you're Samuel Cadena. And Mr. Cadena, did you get someone hired?
Not yet, man. I did get a list of lawyers that I talked to.
Who'd you talk to?
I talked to Adam Parker, Walker Law, Charlie Rojas, Gertz Kelly. They're supposed to call me back, but they didn't.
Okay,
But Thomas and Adams,
all right.
I talked to all.
All right, are you gonna be able to hire someone?
I'm thinking about Mr. Parker. I was just need a little bit more time to raise the money, but
Okay.
I think by
Well,
Friday.
thank you for doing what I asked you to. What I'll do is give you about 30 more days to see if you can get him or someone else hired. If it works out, great, bring that reset notice like I said before. If for some reason it's not gonna work out with any of the ones you've already talked to, talk to a few more. You can tell from talking to them, they all have different payment plans and things like that.
Yes, ma'am.
Step in front of the clerk, she'll give you your reset notice. Diamond James. Good morning, you're Diamond James. Did you get someone hired? Who'd you talk to?
Yeah, I called a lot of attorneys, but a lot of them don't work with criminal lawyers. paper at home.
Why would you leave? That's the one thing that's important today is
I
to,
forgot it because I had headed into work and left work early.
where are you working?
Baymont Hotel.
Okay,
New house.
okay. So where are you on being able to get someone hired then?
I'm trying to save money so I can go with Mr. Burbank. He want 1,500.
Okay. You work full-time at Baymont?
Yes, ma'am.
Okay. Let's see. All right, I'm gonna give you one more reset, about 30 days. Try to see if you can get him hired. If not, if you make payments, bring me receipts of those payments. I wanna know that you're saving the money and trying to work towards getting him hired, okay?
Yes, ma'am.
Step in front of the clerk, she'll give you the reset notice. Burbank. Okay. Kingston Walker. Good morning. Are you Kingston Walker? And Mr. Walker, this is your initial appearance. In cause number 25, DCCR 0861, you're charged with the third-degree felony offense of tampering or fabricating physical evidence with intent to impair, I'm sorry. And that's for March 27th of 2025. You're also charged in cause number 25, DCCR 0862, with possession of a prohibited weapon, and that's also from March 27th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do is reset your case about 30 days to give you some time to try to hire somebody. If you get a lawyer hired before the next court date, just bring the reset notice that you get here today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Tyron Williams. Good morning, sir. Are you Tyron Williams?
Yes, ma'am.
And Mr. Williams, this is your initial appearance in cause number 24, DCCR 2242. You're charged with a third-degree felony offense of driving while intoxicated, third or more, and that's from March 31st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes.
Did you get someone hired?
I had to pay him his money first.
I'm sorry?
I had to pay him his money.
Who's that?
Benjamin Jeffries.
All right, so what I'll do, Mr. Williams, is reset your case about 30 days to give you some time to get Mr. Jeffries hired. If that works out, just bring the reset notice that you get today to him and he'll tell you what to do. If for some reason it's not going to work out with Mr. Jeffries, then I'm ordering you to visit with at least 3 other lawyers. Bring me back the names of those lawyers when you come back to court so I know you're trying, and we'll discuss what your options are. And do you have, as a condition of your bond, the auto ignition interlock device on your vehicle? All right, make sure you keep that up and don't drive any vehicle that does not have that on it, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you the reset.
Good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. Relatively muted start for Fashion Monday in Judge West's court, but we'll keep an eye on it. Let's head to Florida. Wade Mercer starting his first appearances.
Yes, Your Honor.
Great. We do have one interpreter case, Jesus Rivera Calazos. Mr. Cordova, good morning.
Good
Mr.
morning, Your
Cordova,
Honor.
would you please introduce yourself to Mr. Rivera Calazos and make sure he can hear you, sir?
Buenos días, señor Collazos. Yo soy el intérprete Jonathan Córdoba. ¿Usted me oye bien?
Sí, señor.
Yes, he can hear, Your Honor.
Thank you. Mr. Rivera Colazos, sir, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Rivera Collazos, usted está aquí porque está siendo acusado de un cargo de manejar sin tener licencia válida de conducir.
Sir, there is probable cause. There is probable cause for that charge.
Señor, hay causa razonable para esa acusación.
And I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Y voy a asignar a la oficina del abogado de oficio para que lo represente. Voy a pedirle que escuche al señor McDaniel.
Your Honor, we're going to enter a plea of no contest to the charge as listed. The understanding, he'll pay a $400 fine within 60 days at the clerk of court, or he'll serve 10 days in the county jail.
I'm sorry, where would he pay the fine?
Clerk of court. Clerk of court,
Okay.
courthouse.
Okay. Entonces, el abogado de oficio, dice que usted se va a declarar no me opongo a esa acusación. Va a pagar una multa de $400 en 60 días y lo puede pagar en la corte. Y tiene, si no lo paga, tiene que cumplir 10 días en la cárcel.
Your Honor, he's waived his right to a jury trial and call witnesses at that trial.
Y ha renunciado a sus derechos a tener un juicio y ha renunciado a sus derechos a llamar a testigos.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Muchas gracias. El señor Mitchell de la Fiscalía está de acuerdo. Sí, su señoría.
Corporal Drown, under citizenship, there's a blank. Have you heard anything from immigration? Do we have any reason to believe there might be an immigration issue?
No, Your Honor, we haven't heard anything from ICE yet.
Corporal, el policía Brown, ¿has escuchado algo sobre inmigración? Porque no sabemos si hay algún orden de detención. No hemos oído nada acerca de inmigración todavía.
Mr. Rivera Colazos, could you hear that agreement, sir?
Señor Rivera Collazos, ¿usted escuchó ese acuerdo, esa oferta?
Sí, señor.
Yes, sir.
Do you have any questions about that agreement?
¿Tiene alguna pregunta sobre ese acuerdo?
¿Podré sacar las cosas de mi auto?
Can I remove the things I have in my car?
I'm sorry, I couldn't hear you, Mr. Cordova. Could you say that again?
Can I remove the things I have in my car?
I don't know.
I have no idea where your car is at. I'm going to assume law enforcement had it towed.
No tengo ninguna idea dónde está su auto. Estoy suponiendo que la policía se lo llevó o la grúa se lo llevó.
Okay.
If it's been towed, then you have the right to have it returned unless it's held for some evidentiary reason.
Si la grúa se lo llevó, tiene derecho a ir a buscarlo siempre que no sea que lo tengan por razones de pruebas.
If it has been towed and you cannot pay to get it out, you still have the right to get certain belongings out of there.
Pero si la grúa se lo llevó y no ha pagado, todavía tiene derecho a sacar las cosas que usted tenga ahí.
So what you would do is you would contact the arresting agency when you get out and find out what tow company towed the car.
Entonces, cuando sale, lo que va a hacer es llamar la agencia que se llevó, o la grúa, la compañía de grúa, para que pueda hacer arreglos para ir a buscar sus cosas.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No, sir.
No, sir.
Is this a plea you would like to enter?
¿Le gustaría aceptar esta oferta?
Sí, señor.
Yes, sir.
Mr. Rivera Colazos, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Collazos, voy a aceptar su declaración de no me opongo en la acusación de manejar sin tener licencia válida de conducir.
I'm going to withhold adjudication of guilt and sentence you to 10 days in jail.
Voy a suspender el fallo de culpabilidad y le voy a ordenar que vaya a la cárcel por 10 días.
But you will never serve that 10 days as long as you pay the court costs and fines of $400.
Pero no va a tener que cumplir esos 10 días siempre y cuando pague esa multa de $400.
The court costs and fines are due October 20th, 2025.
Tiene que pagar esa multa de costos de la corte antes del 20 de octubre.
If they're paid by that date, this case is over.
Si llega a pagarlo antes de esa fecha, entonces se termina este caso.
If they're not paid by that date, you need to be in court October 21st, 2025 at 8:30 to ask for an extension.
Si no llega a pagarlo antes de esa fecha, tiene que presentarse en la corte el 21 de octubre a las 8:30 para pedir una extensión.
So after first appearance, the clerk's office is going to send this paperwork to the jail.
Entonces, después de esta primera comparecencia, van a mandar estos documentos ahí a la cárcel.
And the court date of October 21st is only if you need it.
Y la próxima audiencia judicial, el 21 de octubre, es solamente si lo necesita.
Lastly, the jail may or may not hold you until noon today, depending on what they hear from immigration.
Y por último, la cárcel puede, si sea necesario, detenerte ahí hasta el mediodía, dependiendo de lo que diga inmigración.
But as long as there's no immigration hold, you'll be released in accord with their policy.
Siempre que no hay una orden de detención de inmigración, de acuerdo a la póliza que tengan.
Do you have any questions?
¿Tiene alguna otra pregunta?
No, señor.
No, sir.
Have a good day, sir.
Ten buen día, señor.
Gracias, señor Cordova.
Thank you. Have a good day, Your Honor.
You too, sir. The next case we have that has friends or family here is Isaiah Murphy. Mr. Murphy, good morning. Mr. Murphy, you're here for first appearance, accused of one count of aggravated battery with a deadly weapon. Your brother is in the courtroom, Mr. Murphy. Mr. Murphy, the criminal history I've got shows no prior history, so I want to make sure that's accurate. Have you ever been charged with a crime anywhere, Mr. Murphy?
No, Your Honor.
And then I'm also showing that you are 19, about to turn 20 years old. Is that right?
Yes, Your Honor.
You live in Sneeds, Florida?
Yes, Your Honor.
All right, let me see if the attorneys have any additional information before I address your bond status. Mr. McDaniel, Mr. Mitchell, I'm the judge that signed the warrant. Although I felt like there might be probable cause for the charge, it was really kind of a close call in my view. There's certainly evidence that he had a firearm along with other people at that event, but what's missing is evidence that he shot the individual or individuals that were shot. I felt there was probable cause. There were two individuals that were shot, and allegedly he was firing a firearm. But if you have additional information, Mr. Mitchell, that would certainly be helpful. Mr. Mitchell, anything from the state?
Yes, Your Honor. We understand that, yes, the reason for the complaint being, less detailed as it is because this is an investigation that's still ongoing. I was informed there may be a possibility that there may be more charges coming regarding Mr. Murphy. All I have is that one of the victims that was in the hospital, Mr. Grant, someone close to him gave a statement to law enforcement saying she saw Mr. Murphy and the other two individuals firing the weapons. Mr. Grant, I found out this morning, he was the one that was struck 3 times below the waist. They operated on his leg for about 12 hours through the night, but they weren't able to save his leg, and it's being amputated today. FDLE has now gotten involved in this investigation. They put up projectiles. They're trying to recover the firearms. There were 27 total shell casings, multiple vehicles shot, and the eyewitness that I have already listed was able to identify Mr. Murphy. So we just request you take that into account when assessing bond.
Mr. Mitchell, let me ask this question. I couldn't tell from the complaint, and law enforcement may not know yet, but I couldn't tell was allegedly, was Mr. Murphy involved with a shootout with the other two individuals that the witness said had firearms? Or were they all, I don't know what law enforcement's version of the dispute was over. That's not in the complaint at all.
So
I don't know who to keep him away from. I don't know that I need to do a condition, no contact with someone else,
I got you.
because I don't know if he was in an argument with someone allegedly, or if I have no idea. Obviously, I got to keep him away from the person that was shot. But
Yeah, and this situation appears to just be like an argument that escalated into a fight in which one of the co-defendants, Mr. Patterson, punched Mr. Wilson, and it's saying that when Mr. Wilson went to go punch Patterson, that's when the gunfire started. And, they allege that during it, Mr. Murphy was involved in it, and he pulled out an assault style weapon and started shooting.
I read all that, but you don't know why Mr. Murphy was involved, or
That
Mr.
part.
Grant, law enforcement at this early stage doesn't know if they were involved at all.
Yes, at this
Okay.
point, no.
All right, thank you. Mr. McDaniel, anything on behalf of Mr. Murphy?
Your Honor, it's tough when, obviously, it sounds like he had an AR-15. I don't know what the injuries, if they were consistent with an AR-15 or handguns. There's apparently lots of guns that were being shot off. So, handguns and, other people had handguns. So it's very confusing, obviously, but I'd like to know if he actually shot anybody, for a battery charge. I don't even know that he actually even shot anybody.
Yeah, I think when I signed the warrant, my thought was the doctrine of transferred intent, which, as you know, says that even if he's aimed at someone else and he strikes the wrong person, then that's still aggravated battery. So that's why I found probable cause, but I would like to have more information. So, Mr. Murphy, understand, I'm about to set you a bond, but you need to understand, if this charge changes, the bond could very well change and very likely would change. Also, the other thing that can happen is if there's additional evidence from ballistics or other evidence that shows your firearm caused the injuries, the bond could go up. So likewise, if there's evidence that shows that your firearm did not cause the injuries, the bond could go down. So given what I've got now, which is very preliminary investigation, I'm going to set your bond at $10,000 cash or surety with a condition of no contact with alleged victim. Cash or surety means you can go through a bondsman. You do not have to come up with all the money. So if yourself, your friends, or your family post the bond, you'll be released. You can have no contact at all with the alleged victim. And the other person that was shot that supposedly had a firearm too was Mr.
Patterson.
I need a first name. No, let me ask this question. Are you legally related to Trevante Patterson, Mr. Murphy?
Yes, Your Honor. That's my brother.
Okay, I'm not going to do a condition no contact then, since that's your brother. I wasn't sure if there was a legal relationship or not, because the complaint doesn't tell me that. So the only person you can have no contact with is the alleged victim, and that is Mr. Grant. So you're going to get to use the phone in just a few minutes, and your brother is in the courtroom. He's heard all of this. Let me see if he has any questions first. In the courtroom, sir, do you have any questions? Sir?
Sir.
Do you have any questions? He'll be appointed a lawyer at some point if he requests one and he qualifies for one. So that you may want to leave your information at the public defender's office, and when a lawyer gets appointed, that lawyer will contact you. On the other hand, he has the right, or he or his family have the right to hire an attorney if you want to do that also. So it just kind of depends on what y'all decide to do. But he has a right to a bond. I've set him a bond. If it was my brother, my concern would be you post a bond, you come up with that money, and hopefully further investigation is either going to make the case stronger or going to point it at someone else. But what Florida law says essentially is if he's shooting a firearm and he's aiming over here at somebody and he hits you, that's still aggravated battery. So that's why he's charged, is there's no direct evidence he was shooting at Mr. Grant, at least not in this complaint. If they develop that evidence, it could go to become even more serious. Any other questions? All right. And Mr. Murphy, do you have any questions?
My phone was seized yesterday without a warrant. How do I go about getting my phone?
Okay, if they have the right, sometimes law enforcement takes phones for evidentiary value, and if they seek to get a search warrant to get the contents of the phone, they have to apply for a search warrant. So it's early on. I don't know that you're going to get that phone back in the next few days, because what they're probably going to do is see if they have a right to search inside the phone, determine locations, determine text messages. It just depends on what all information they have. They can only get inside that phone with a search warrant or an exception to the search warrant requirement. So right now, you're not going to have that phone at least for the next few days. Any other questions, Mr. Murphy?
No, Your Honor.
All right, sir. Wish you the best.
So on last Thursday's sidebar, I got asked the question, what are the cases that bug me the most? And my response was those who are young, who have thrown it all away. And it looks like this young man is potentially on that list. I don't get it. I don't know that I ever will. Back to Judge.
Case, there is probable cause for the charge. Mr. Collins, similar to Mr. Murphy, I see no prior criminal history in your case. Is that accurate?
Yes, sir.
Mr. Collins, are you employed?
Yes, sir.
Portable service is what the jail sheet says. What kind of business is that?
Mechanics and welding and fabrication.
Okay. Let me see if the attorneys have any additional information in your case, Mr. Collins, before I address your bond or release status. Mr. McDaniel?
Your Honor, we just asked for a possible cash bond.
Mr. Mitchell?
No objection to a cash bond.
Mr. Collins, you're charged with a first-degree misdemeanor. I'm going to set you a cash bond accordingly. Your bond's going to be $250 cash. You have a condition of absolutely no contact with Ms. Young. That means no contact whatsoever while this case is pending. No telephone contact, no electronic communication. Can't send somebody else to send her messages. No contact at all. That $250 cash bond is posted. You'll be released. I'm going to ask the jail to give you a notice for your next court date. So,
Hey, what about
September 29th at 9 a.m. will be your next court date. Mr. Collins, do you have any questions? You ladies have any questions? No? Any questions?
No questions. No, sir.
Have a good day, Mr. Collins. Mr. McDaniel, that's it for people that have friends or family in the courtroom. So let's go back to the top of the list where we left off, and that would be actually Armstead. Therese Armstead will be next. Mr. Armstead, good morning.
Good morning.
Mr. Armstead, sir, you're charged with one count of possession of cocaine and one count of petty theft, third or subsequent. There's probable cause in the complaint for possession of marijuana, but I don't see that charge. I don't think they charge you with that, even though he laid out the case. Mr. Taylor, you don't have another paperwork, another sheet there that shows as a third charge, do you?
No, Your Honor.
Okay.
No, sir.
So you just got those two charges, Mr. Armstead. I did look at your criminal history. It looks like you got out of prison in June, month before last. As a matter of fact, today's exactly 2 months ago you got out of prison. Is that right, sir?
Yes, sir.
Mr. Armstead, I think you're entitled to a bond. I'm going to set you a bond, but I want to listen to the attorneys before I do so. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Armstead, given your criminal history, your bond's going to be $10,000 in each count. Your total bond today is $20,000 cash or surety. Mr. Armstead, your bond has a condition of random urinalysis, and your bond has a condition of no contact with any Dollar General while the case is pending. Mr. Armstead, you'll get to use the phone in just a few minutes, sir, to try to contact friends or family to try to post the bond. If you post it, you'll be released. If you're not able to post the bond, Mr. Armstead, then the public defender's office will be in contact with you at the jail. Do you have any questions?
Yes, sir.
Wish you the best, sir. Cheyenne Mills Wright. Ms. Mills Wright, good morning. You're here for a failure to appear for a violation of injunction charge, ma'am. And Mr. McDaniel, I know that you and Mr. Mitchell wanted to talk to me about this case. You just want to bring her back tomorrow once we have a time to talk about it, or what's your preference?
We can, Your Honor. I was just going to ask the court to consider letting her out, I guess, Your Honor, because there was this is a case where she was mistakenly given the wrong date for the 15th. She did show up on the 15th. It didn't have a time on it. So, I think I'll just go down the line of basically it's clearly not an intent to not appear at the court because, there was no intent there. The notice was there. She's been in the hospital with pancreatitis, so that's the reason why I have not been able to get a hold of her, since she got out of jail and, she's been in and out of the hospital. And, due to that mistake, and she clearly showed up on the 15th, we'd ask the court to consider just letting her off the bond. And I will continue to talk with, Mr. Mitchell about the case and,
Let me
go
look
forward
at that. This is a case where the jail gave her the wrong notice. The clerk's office sent the right notice to her and to her bondsman, which would have been for Wednesday, which would have been the 13th. She didn't show up Wednesday. I did not issue a warrant. I said, let's wait till the 15th, give her the benefit of the doubt. Then when she didn't show up on the 15th, I issued the warrant. So you're saying the notice to appear for the 15th did not have a time on it? And it
didn't have
doesn't.
a time on it. It doesn't have a time on it. And she's been in the hospital. Also, she can't get mail at the address that it was sent to because she not have contact at that address. So it's kind of she clearly
Well,
showed up.
it was sent to her bondsman too. That's the problem she has. That's why I issued the warrant, because it's the bondsman's responsibility to get her here. And
It just goes into intent, Your Honor. I don't think she intended to miss court because she showed up. She showed up. So
Mr. Mitchell.
I just wanted to let you know that she did show up on Friday. Deputy Spates told me that he was actually the one that took her into custody downstairs. I think she showed up about 11:30, somewhere around that time. So just wanted to put that out there.
Yeah, Ms. Mills, right. I think Mr. McDaniel is correct. I think I've got to give you the benefit of the doubt. I don't know how the jail came up with the 15th. Whoever gave you that notice was way off, and even worse, they didn't have a time on the notice. So Corporal, whoever gave that notice needs to be retrained on notices, because that's not much I can do if you say you got to be here on the wrong court date and it don't even have a time on it. So Ms. Mills, right, I'm gonna let you back out, ma'am, on the same bond you were on previously. You got the same conditions of that bond that you previously had. Remember, I've already told you, I think now twice, the injunction is still in effect, and that it means 500 feet, and don't go within 500 feet of that person or his residence. And if you do, you're going to be in jail with no bond. But I can't do it today. I can't justify keeping you there in my mind, given the errors made by the person that issued the notice. Mr. McDaniel, what court date do you want to set for us so we can go ahead and give her notice for that date?
September 17th, Your Honor, and we're going to try to do a trial on September 22nd. At least for right now, we'll put it on that trial date, but I intend to hopefully have it ready to be tried that day.
September 17th and September 22nd, Mr. Mitchell?
Yes, Your Honor. That was the agreement we had.
And those notices will be for 9 a.m. for both days, Mr. McDaniel?
Yes, well, the trial may be 8:30. And I'll remind her on the 17th, but 8:30 for the trial date.
So Corporal, please, on the 17th, we need to put a notice for 9 a.m. and on the trial date for 8:30, please, Corporal. Ms. Mills, right? Just don't violate your bond, okay? Any questions?
No, sir, I don't. I appreciate you.
I wish you the best, man. We'll see you on that court date.
Okie dokie, we're going to go over to Judge Stevens in just a moment, where it looks like he has a contestant who fits fairly well with our default August theme, which is kind of a sad theme, but these things roll that way sometimes at TCF. But before we go there, I did want to take a moment and discuss the sponsor of today's show and a good partner to the channel, and that is Aura. So you've heard me talk about them a lot. They are a one-stop shop, in my opinion, when it comes to protecting yourself and protecting your data online. But I wanted to share an email that I got with, share with you rather, an email that I got from Google the other day. It says, we're writing to let you know about an event that affected the data in one of Google's corporate Salesforce instances used to communicate with our customers. Our records indicate that contact information and related notes were impacted. One of Google's corporate Salesforce instances was affected. The threat actor had unauthorized access to this instance. The affected information was basic contact information such as business name, phone number, related notes that are used by our staff to communicate with you and keep track of you and your needs. That's super cool. So as many of you know, I run multiple businesses, not just this channel. It means that I have a rather extensive and expansive relationship with Google, and it's nice to know that a whole bunch of my data has now been taken from their systems, but it's not surprising because this stuff happens every day. But this information, at the very least, is going to find its way onto the dark web, probably in the hands of data brokers as well. But this is where Aura comes in. They have dark web monitoring. They have the ability to go to the data brokers, and they've done it for me with over 50 different brokers now at last count, to remove my information from those places. They also have spam and junk removal, antivirus, VPN, credit monitoring, you name it. They've got it to protect you and your family when it comes to your presence online. You know, I didn't do anything other than have a relationship with a very large company, and now my data that they had is out there because somebody who was a bad actor broke in and stole it. But luckily, I don't necessarily have to worry about that so much because Aura will keep track of it for me, and they will make sure that any information that can be removed will be removed, and if it can't be removed, I'll at least know where it is so I can deal with it. So listen. Go to aura.com/TCF and you get a 14-day free trial to try these guys out. And if you don't believe what I'm saying about Aura, just type in the comments what's your experience, because I know there's a couple of people out in the chat right now who will tell you what Aura has been able to do for them in just a couple of days. 14 days is more than enough time for them to find where your data is, start the removal process, and allow you to make the choice whether or not you want to continue with them. So there's absolutely nothing to lose and everything to gain. I encourage you to go there, aura.com/TCF. Sign up is simple, it's quick, it is worthwhile. Take care of yourself, protect yourself online. I don't leave myself vulnerable for the very reason that I just read to you, and you shouldn't either. Aura.com/TCF, 14 days for free. Go give them a try and support the people who support this channel. All right, let's go to Judge Stevens and see what he's got going on.
22-39843, the state of Texas versus Kevin Charles Cooper. Present with his attorney, Mr. West, and the state's attorney. Does the defendant waive hello? We get some prior convictions here, don't we?
Yes, that's right.
So you're charged with the second-degree felony of failing to comply with sex offender registration. And then 2016, it looks like you were convicted of that. And then in 2017. And in 2008. Okay.
And 21.
Well, it ends with, I think they just got tired of writing and.
I thought
But-
he's correct.
but- I understand that. Rick, what you have to be very careful about, of course, is these priors, if they're in sequence, that makes you a habitual felon. They're not reading that way, but he said there's a 21, and it's not in here, and it's not an issue today. But if you were convicted in 21 and
It's not to do.
I don't know, but if that was a crime that was committed after any of these were final, and then you any of these are final, then you commit thereafter an offense, then you're looking at potentially habitual felon, which is where a minimum of 25 is serious.
That's why I was kind of like, well,
I don't know what that is, but it's not relevant today.
Yes.
But it's something to think about, to be careful about.
yes, sir.
Your Honor, we fashioned this as a third degree. The primary count is.
Was it attempted or something?
No, sir. The initial offense he has here would be a state of felony because of his reporting requirements, is a 10-year requirement. The adding one of the other three paragraphs will make it a third degree. The caption on the indictment is incorrect.
What should it be? It should be a third degree.
The caption should read third degree because
I mean, you said something about state jail felony.
Yeah, the original paragraph is a state jail felony.
Well, it takes more than just one prior
No, sir.
conviction.
No, sir, not under
A state jail plea, right?
Not under the specific enhancement paragraphs of chapter 62. Because if he's got a prior registration offense, it goes to the next highest degree, which is a third degree.
Okay, everybody agree with that?
Yeah, John, because one of his priors is felony register. So that's why.
But one of those priors has to be used.
Yes, sir.
In the plea.
So that's why I need the initial paragraph and one of the other
Which
paragraphs,
one?
Judge. To me, it makes no difference, whichever one the
All right.
defendant wants to plead
In
to.
paragraph 1, and again, the defendant waives a formal reading of this and we can go inside.
Yes, Your Honor, please.
Paragraph 1 alleges that
I've got a bandage.
that you have a reportable adjudication of indecency with a child. You have failed to comply with requirements under chapter 62 of the Texas Code of Criminal Procedure. And it's not the penal code, it's the Texas Code of Criminal Procedure. Is that correct?
Yes, Your Honor.
And which requires you to comply with those requirements of reporting to local law enforcement authorities as your primary registration authority by the Texas Department of Public Safety. And you must report in to Beaumont Police Department. You live here, residents here. And this goes on to allege that you failed to report at least once annually, which is what you're required to do during a period within 30 days before and not later than 30 days after the anniversary of your birthday, June 2nd. So you've got that window 1 month before and 1 month after, 2 months surrounding your birthday to report. And namely, during the period from May 3rd, 2020 until July 2nd, 2020, it is alleged here in Jefferson County, Texas, you failed to verify the information on the on your sex offender registration form, which is maintained by local law enforcement. And paragraph 2 goes on to allege that you have been convicted of a similar offense on November 28th, 2016, out of the 331st District Court of Travis County, Texas, where you were convicted of the offense of sex offender duty to register. And thus paragraphs 1 and 2 constitute a third-degree felony. Does everybody agree?
Yeah. Yes, sir.
Which means you face a term of not more than 10 years or less than 2 years in prison if convicted, and a fine up to $10,000 can be assessed. Do you understand the punishment range here, sir? Yes, sir. An agreement has been fashioned. In your case, you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. There would be terms and conditions of probation. The very foremost is to register.
Don't have to be. Hold on. He's already beyond his 10 years now.
That's correct.
Oh,
He had a 10-year period.
okay. It ended within 10 years. All right.
Yeah. So.
Well, there will be terms and conditions of probation, which are normal and customary. Make sure you, they will be reviewed with you and the probation officer here. Make sure you follow them. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison. Do you understand what you're facing here?
Yes, sir.
They answered this.
How do you plead to paragraphs 1 and 2 constituting this a third-degree felony, guilty or not guilty? Are you pleading guilty voluntarily and because these allegations are true as they are alleged in paragraphs 1 and 2? Yes, yes, together. And paragraph 2, that prior conviction in 2016 out of Travis County, 331st District Court in Texas, that's true and correct as it is alleged.
Yes, sir.
And you're pleading true and correct to that voluntarily.
Yes, sir.
Oh, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? If you understand it, discuss it with your attorney. Are the contents all clear and correct?
Yes, sir.
States Exhibit 1 tendered into evidence
No objection.
without objection admitted.
Says
Just one second. What I'm going to ask to do is change the caption on this to reflect that it's third degree.
Okay. You got it early on? So, we think the name rankings. So why don't you just, at least it's when you get this, discover it in the case, you're not. Me. No, there it's the guys. Yes. What in some of those issues? Well, like I said, with that and the university, simplifying the protections it's not increased and whatever things that we're going to do. And they,
All right, if nothing further to add, I'm going to find you pleading guilty to paragraph 1, true to paragraph 2, constituting third degree felony, a failing to comply with sex offender registration requirements. Under the laws of the state of Texas, you were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting you from State's Exhibit 1 admitted here. That states that you are totally satisfied with the representation by your lawyer. You were mentally competent to enter your guilty plea. You understand and appreciate the consequences of pleading guilty. You're giving up your rights to a jury trial and the rights to experience confrontation and cross-examination of witnesses. And all of this is true, so help you God. Is that so? State's Exhibit 1, part of the record for all purposes. I now find the defendant guilty in paragraphs 1 and 2 constituting this third degree felony. I'm following this agreement. You will hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 10 years. If that confinement is suspended, you are placed on regular probation for 10 years. There will be a fine in the amount of $500. Other terms and conditions of probation, which are normal and customary for this office, will be reviewed with you and the probation officer here in just a moment. Make sure you follow these. You know what can happen. Up to 10 years in prison is riding on this. You understand what has happened today, sir? Good luck to you.
Okay, let's change it up a little bit. I don't normally go to these things this early, but there is a parole hearing in Louisiana, but it's a 5-member panel, which they actually call out in the feed this morning. So I don't know why there's 5 members, but let's figure it out.
Seated at DOC headquarters today. We are a 5-member parole panel today. So we have seated to my far left, Mr. Chucky Tillis. My immediate left is Mrs. Carolyn Stapleton. My immediate right is Mr. Danny Barra, and to his right is Mr. Pete Freeman. Would the staff here at DOC headquarters please introduce yourselves for the record?
Sure.
Williams. All right, and our first remote location this morning is at Union Parish Detention Center. Would y'all unmute your microphone, please? Sir, can you hear me? Their audio's not connected. Mr. Mouillet. Can you hear me? It looks like they're trying to get it. Yeah.
While they figure out whatever it is that they're trying to figure out, let me remind all of you that this show is now a podcast. You can find us on Spotify, Apple, iHeart, Audible, anywhere where you get your podcasts. So if you need a more portable version of this show, be sure to check that out. And if you use a service where you can leave a review, please do so. It will help us get found by others.
Still can't hear you.
They're coming to fix it if you can hear me.
I can hear you. We can
Okay.
hear you.
Okay,
All right,
thank you.
So I'll repeat, we are at Union Parish Detention Center, and I'd like the officer who's remaining in the room with you to please introduce yourself for the record.
Good morning, I'm Sergeant Cooley.
Sergeant Cooley, thanks for accommodating us this morning. And is this is it Mouye?
Yes, ma'am. Jesse
you-
Mouye.
What is your DOC number, Mr. Mouye?
My name is Jesse Mouye. My DOC is 704797.
Let me, can y'all turn the radios down a little bit? That's all we can hear. So let me read some identifying information into the record, Mr. Mouye, before we get started. You're classified as a first felony offender. You're currently serving a 15-year sentence. You were sentenced in Livingston Parish in October of 2015 for attempted first-degree murder, 2 counts. You received a 10-year sentence. Aggravated escape, 5 years. Aggravated criminal damage to property, 5 years. Unauthorized use of a motor vehicle, 5 years. And then also illegal possession of stolen things, 5 years. Those sentences are running concurrently, so it's a total of 15 years. Your parole eligibility date was January 30th of 2024, and your good time release date is August 3rd, 2026. Does all that sound correct to you, sir?
As far as my rap sheet, everything is pretty active besides apparently the stolen things is not on my rap sheet. That's about it.
Okay. But you agree you're serving a 15-year sentence?
Yes, ma'am.
Okay. Let me recognize we have some folks that have joined us today who want to have input. We have in support your fiance, Brittany Gunter, your grandmother, Brenda Sander, and we'll call on them. They're on Zoom. We'll call on them in a few minutes. Here in opposition with us in Baton Rouge, we have the victim, Mr. Jeremy Pratt, on Zoom from the DA's office in the 21st Judicial District. We have Tamika White, Michelle Sparks, Alexis Taylor, and Tatlin Costa. And Ms. Taylor will be speaking at the appropriate time. First, Mr. Mouye, before we start our process, we want to get your statement. You know, why are you in jail? What did you do? And why do you think we ought to vote to let you out early?
Well, upon the time that I caught my charge, I was, how can I say, I was young, I was dumb. One of them just young teenagers that thought they knew it all. And over the time of being incarcerated, I have learned fortitude. I have not let the corruption of my mind tempt the foundation of my heart, nor have I've let the corruption of my heart get to my mind. I have felt weak. I was on drugs at times. I'm now sober, 4 years strong. I've realized that I do not want to die in prison, nor do I want this to be my home. And I'm internally sorry, and I don't think I could ever find the words to be able to say how sorry I am. I'm only able to show with the actions that I can prove to myself and to society to show them that I'm a better man, I'm a better father, I'm a better son, a better person in general within myself, that I found myself since I've been incarcerated.
Okay, well, thank you. Let me ask Sergeant Cooley, is it? do you know Mr. Mouye?
Yeah, I have been around Mr. Mouye for about a year now.
Okay, because he's been at your facility about a year. Is there anything you can tell us about Mr. Mouye?
Well, from my experience with Mr. Mouye, he always been respectful. He always been helpful. He ain't never just caused us no type of problems or anything. So, as far as Mr. Mouye, I just know he's a person that tries. I can see, you know, he tries to do things around the jail because he's in trustee. So anything we ask for, he got respect. He show respect towards us and everything. So as far as I can say about Mr. Mouye, he shows a lot of respect. He's a very nice person. As the year I've been doing.
Has he had any write-ups in that year?
No, ma'am.
Okay, well, thank you. We appreciate your input. We're going to go ahead and hear from the folks who are here in
Yes, ma'am.
support. Mr. Mouye, we would like to hear first from Brittany Gunner. Go ahead.
Today.
We're having a little audio
All right, so
issues.
Jesse Mouye is my fiance. Not only my fiance, but
yes, we can hear you.
Can you hear me? Okay, yes, ma'am. So, I'm sorry. Not only is he my fiance, he's been my best friend for years. And I've seen changes in him through the years of being incarcerated. And I believe that he's grown out of the ways and stuff, and he deserves a chance to be able to be out and start new, start fresh again, and get his life, back up and going.
All right, well, thank you. Thank you for speaking with us.
I just hope that y'all are, confident in allowing him to deserve the chance to be able to get out.
All right, yes, ma'am, thank you. Could we hear now from Ms. Brenda Sander?
Yes, ma'am. Hi.
Good morning.
Good morning. Well, I would love for Jesse to get out. I feel he did his time, and I know he's sorry for the things he's done. Jesse's had a hard life. I'm not no excuse, but he has extra hard life. And Jesse at one point in his life stayed with me for quite a while, and he did great. And I just believe it was the people and some of the people he was around. But inside, Jesse's a very good. He's a good person. He will help anyone. And I believe he's going to do good when he gets out. I really, really do believe that. And I have breast cancer, and I would like to.
Yes, ma'am. Thank you for speaking with us this morning. It's good hearing from you. We're gonna now move on to hear from the opposition. First, we'd like to hear from Mr. Pat. Good morning.
I don't think he should be out. I think he's a dangerous person. I think that what happened on that day, the way it happened, I don't feel he should be out. I've heard different things on his behavior while he's been incorporated, while he was still in Livingston before he got sentenced, that when he got out, the first person he was going to find was me. And I'm not particularly fond of looking over my shoulder.
Thank you for the time to be here this morning.
Yes, ma'am.
We appreciate hearing from you.
Yes, ma'am.
Y'all have any questions for the officer? Thanks, sir. And I think it's Miss Tamika White that wants to speak on behalf of the VA. Ms. White?
Good morning.
Good morning.
Okay, I wanted to make sure everyone can hear me. I just want to say that on behalf of the state that we support Officer Pat and the other officers that were involved in this situation. It was very severe. Not only did it put the officers' lives in danger, it put many civilians' lives in danger. Even after the accident, he began to flee, and I understand how he's saying that things have changed in his life. And yes, everyone does deserve a chance, but I'm not sure he realizes the severity of the incident that occurred. And I would hate to be Officer Pat and feel like I have to watch over my shoulders.
Great. Thank you.
And that's it on behalf of the state.
We appreciate hearing from you this morning. Thank you so much. All right, Mr. Mouye, your case was assigned to Mr. Freeman. Would you answer his questions?
Okay, Mr. How many years have you served on this sentence?
13.
Well, 13, okay.
13.
Okay, tell me something. I mean, what would make me think that your behavior is gonna change? I mean, even in prison, you've done some things that assaulted a guard, tried to headbutt him. I mean, give me some assurances that you not get out there and go after, Sergeant Pratt.
In the time of my incarceration, I struggled with a lot of addictions and I've struggled with a lot of different things. But since I've been down, I have learned that family is the most important thing. And I buried my mom. Well, I didn't really bury her because I didn't get to put her to rest yet. When people's angry, they say things, and sometimes they say hateful things that they don't mean. Sometimes we do things in life where we grow up and we understand that if we continue to stumble, that we won't better ourselves and it becomes an addiction. And there's a time in a person's life when he just has to accept the factor of growing up and put everything to the side and to be able to be a man. Like the Bible says, when I was a child, I thought as a child. But when I became a man, I put the childish things to the side and I thought as a man. So I'm sorry that if they feel that way, and I can understand it was over a decade ago, but at the same time, when I fled in the scene, I was a little kid and I was scared. I didn't know what I was doing. I'm a first-time offender and I watched my dad die in prison and I didn't want to follow his footsteps. And now that I've been here, I understand that if I mess up again, this could be my home. And I don't want that. I want a chance to be able to create a home.
Okay, next it is, I know, they probably don't offer too many classes over there. Do they offer any classes over there?
Not here, they don't.
Okay, because you've only taken, one class, living in balance. You tried management, but you, were removed for excessive absences. Is that the only class you took?
No, sir. I got all my things right here.
Right.
Maybe
Okay. The only class you got that's giving you credit.
the only one that takes credit, but I took the other ones just to take them for a learning experience. So I have a certificate of living in a balance from Dixon Correction. I have a baptism certificate. I have the company you keep certificate. I have a completion of substance abuse education. I have a PRIDE, which is called Prisoner Rehabilitation Through Integrity Discipline of Education.
Right, we got that. I got all those certificates. You don't have to read each one of them out. I have those. I was just talking about classes that give you credit. Okay.
Yes, sir.
And, last but not least, I'm gonna note that there was a lot of law enforcement opposition. Well, 1,740 days of good time. I've never seen that in my life. Your last write-up was 5/14/22. You've gotten 43 write-ups. Like I said, I talked about the other one, but I have no further questions. And we still have mandatory courses left for him to have to take.
Any other questions?
I've got a question. Tamika. I've got a question if you can help me out here.
Yes, ma'am.
Carol, we know each other from way back.
Yes, ma'am.
This is about what brought them to the house that night, which was a domestic violence situation. And if when he does get out, because he's got a good time date, the victim, and I'm not going to mention her name or anything like that, will she know that she can file for a protective order against him? Because there were other people involved that's going to be frightened of him. I heard the deputy and everything, but there was a reason they were called at that house that night that involved bodily harm, domestic violence and strangulation. And, so the victims that were there get a protective order against him.
Yes, ma'am. If we're notified that he's being released, we're going to reach out to them to see that they, follow the steps in order to do that.
Yeah, because he's got a good time date for things, well in a year. So that's what 2026. So just 1 year from now, he's got a good time date. Just wanted to make sure. I'm sure they're still fighting also. Thank you, Tamika.
You're welcome.
Any other questions? All right, I don't see any other questions. Mr. Mouillet, I think we're ready to vote. Mr. Freeman will be voting.
Okay, Mr. Mouillet, I'm gonna tell you, you talked good today. You made good sense, but hopefully you'll start making some good decisions. With your disciplinary action and the serious nature of the incident offense, my vote today would be to deny. He still needs his pre-release program also.
Mr. Tiller,
My vote also is to deny. I agree with Mr. Freeman.
Mrs. Stapleton.
My vote is to deny, and you have a very violent criminal history against other people.
Mr. Bauer.
Concur with everyone for the same reason.
My vote today also is to deny based on the reasons that have already been stated. So today, Mr. Mouillet, your parole's been denied. Good luck to you, sir.
God bless y'all.
We're going to sign off from Union Parish. It's 9:19.
Denied.
So while that was going on, I looked up information as to why that's a 5-member panel when they usually have 3. And basically, there are certain cases in Louisiana law that require a 5-member panel. It has to do with the severity of the crime. For example, any crime of violence that is against a peace officer requires a 5-member panel. Certain crimes that would involve like a life sentence require it. Certain crimes that involve murder or attempted murder, which I believe it was attempted on this one, depending on the circumstances, require a 5-member panel. So that's the reason. And apparently, if you get to a 5-member panel, from what I'm seeing, it also requires a unanimous vote. So that explains a little bit of that for us. Let's go back to Texas and Judge Stevens. He has a fresh contestant.
And you are here. Mr. Macon is your attorney. He has filed a motion to withdraw as your attorney. Have you heard about that?
Yeah.
Okay. And there were 2 different reasons. The health reasons, which he's getting better here, but the other reason was communication is broken down between you and him, according to this, and he is unable to represent you. It's cryptic. I don't understand. I don't know what the details are about that. Do you? Do you know what we're talking about?
No, not really.
Okay, I don't really either, but for the record, if you can summarize, Mr. Macon.
My client, his father, his mother, and his sister have all promised to pay, and nothing has been forthcoming.
All right. Are you able to pay the defendant, the defense attorney?
Paid everything up front already.
Well, how much was that,
7,500.
sir?
7,500.
7,500?
Under the contract I had with Mr. Wilson,
I hate to
clearly states that there's a trial fee, and that has not been forthcoming.
How much does he?
$7,500 more.
Are you able to pay that? No.
No, sir.
What are you asking?
That I withdraw it. I would say appoint me, but I'm not on the appointed list.
No, you're not on the appointment, yes. The next person on the appointment list would be selected. Anything from the state, Dan?
I have no objections, Judge.
All right, a couple of things. I'm going to grant the motion to withdraw. Keep putting this thing off. I'm going to grant the motion to withdraw. Mr. Macon will be released. You need to fill out an indigent form before you leave the room on finances. And if I declare you indigent, someone will be appointed immediately to represent you, and we'll set this for trial as soon as they can be ready.
All right.
Give it to him, let him fill that out. And we'll place this back on the trial docket. This is what you want, right? Have y'all talked about disposing of the case?
Making an ask.
Exhausting? Okay, all right.
It'll have to be a trial.
Okay, all right. Then I'll keep it on the trial docket, and I'm gonna I'll set it for 6 weeks and get somebody today. Thank you. All right.
All right, let's stay in Texas, but in our efforts for 9 to 11% more Judge Boyd, let's go there. Or not, she's muted herself. So let me figure out where we can go with her where she's not muted. In the meantime, let's go back to Florida and Judge Mercer.
Morning, Ms. Holloman, you're here because you've been accused of violating the terms of your probation in case number 25-261MM. I'm appointing the public defender's officer to represent you, Ms. Holloman. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Holloman. She's going to admit that she violated the probation. She has 5 days jail credit. The remaining fine is owed on the case. And I think she just wanted to put some things in the record, and and whatever the court does is fine. So go ahead, Ms. Holloman.
Okay. Hang on just a second. Ms. Holloman, I need to get your admission on the record first. Ms. Holloman, let me get you to raise your right hand, please. You solemnly swear from the testimony you're about to give in this case will be the truth, the whole truth, and nothing but truth, so help you God.
Yes. Yes, sir.
Ms. Holloman, you're accused of violating the terms of your probation on a second-degree misdemeanor, ma'am. The charge was petty theft. And you need to understand you have a right to a VOP hearing, ma'am. If you exercise that right, this matter will be scheduled for a violation of probation hearing. At that hearing, you will be appointed counsel. Mr. McDaniel will be representing you, and you'll have a chance to testify and cross-examine any witnesses that the state puts forth. Do you understand all that, ma'am?
Yes, sir.
Ms. Holloman, you also have the right to waive that right to a hearing. But if you waive that right to a hearing, ma'am, what that means is you're waiving your right to call and cross-examine witnesses. There will not be a hearing. I'll listen to you. I'll look at the file. I'll listen to the probation office, and I'll impose your sentence today. Is that what you want to do? You want to waive that right to a hearing, ma'am?
Yes.
Ms. Holloman, I'm going to accept your admission that you violated the terms of your probation. I'm going to find that admission is freely and voluntarily entered. What I want to do is tell you what the accusations are against you, and then I'm glad to listen to anything you want to tell me. You're accused of 3 violations. According to this, you're put on probation May 16th for petty theft for 6 months. That would have been May. And then, according to this, you didn't report July or August. Now that implies, and Mr. Goodson will clarify, but that implies you reported 1 month, exactly 1 month, and then you just chose to disappear. You never paid anything towards court costs and fines, never paid anything towards restitution, never paid anything towards cost of supervision. So those are things that you're accused of doing. Anything you would like to tell me in response to any of that, I'm glad to listen.
I got my certificate as soon as I got out, but I wasn't able to. My mom had passed away and I kind of got in a fog. I'm sorry, Your Honor.
Well, let me ask you, I'm confused. What certificate are you talking about?
I did the theft awareness class online. I did that.
Okay.
I got the certificate.
Okay, and when did your mom pass?
She passed about a month ago in Alabama.
Do you know what date? Do you know what date she passed away on?
It was like the 11th.
Of what month?
July.
Okay, so what you're accused of is, Mr. Goodson, what dates was she supposed to report in, and what else do you have?
Her scheduled check-in was June the 5th of each month. Her first check-in was June the 5th. She did check in on June the 5th. What she's talking about, she didn't make a payment then. She said she would pay later. Mr. Ham did receive her retail theft program certificate on June the 10th. According to the comments that Mr. Ham put in the database, we have not heard from her since June. I'm sorry. She actually checked in June the 3rd. I apologize. So she was 2 days early, but we have not heard from her since June the 3rd.
So she was supposed to check in July the 5th?
And August 5th.
And
yes,
again,
sir.
August 5th.
Yes, sir.
Okay. And you say that your mother passed away when, Ms. Hollerman?
It was the beginning of July. She ran into a tree.
Okay. So was it unexpected? She wasn't like she had been sick for a while. She just passed away suddenly?
Yeah, she had some problems, and one morning she just came home and she ran into a tree in Pinkert, Alabama. I'm sorry.
Okay.
In Pinkert.
I'm sorry for your loss, Ms. Hollerman. Let me just get a little more information from you. So it's certainly understandable if she passed away early July. Did she pass away before the 5th or after? I think you said 11th. She passed away after the 5th?
It was the beginning of July. It was the very beginning of July. I'm not exactly sure of the exact date, but it was the beginning of July.
Okay, and that's why you didn't report for July, correct?
Correct. I'm sorry.
Tell me about the next month. Is there a different reason why you didn't report a month later, or is
Well, I
same
had
reason?
an issue with this guy, Daniel Farcash, and he ended up stealing my vehicle. So that was the issue where I couldn't get up there, but I still could have tried to make payments, but I've kind of been behind on bills since my mom, and I just wasn't able to. But I did the certificate as soon as possible, and I have the money to pay. I could pay the probation today.
Where do you live at?
I lived down the road at 2776 Cobblestone. And
Where's
I have a dog
Cobblestone?
there it's been alone.
Okay, where's Cobblestone at?
Right down the road here in Pebble Hill Estates.
Pebble Hills. Okay.
Oh, yeah.
I'm looking at your criminal history from the state of Alabama. How old are you, Ms. Hollerman?
37.
And do you have a job?
I do. I work for OnStar.
Is that a full-time job?
Yes, it's a work from home job from the computer.
But you do that 40 hours a week?
About 25 hours a week.
Okay, that's not what full-time means. Okay, full-time means 40 hours a week to most people. So it's a part-time
Part-time.
job. Is that right?
Yes.
And how long have you had that job?
Since of December of 2023.
When's the last time you worked at that job?
Was passed recently. Every day I have from
So
home.
when is the last time you worked at that job?
It would be Thursday.
Okay. You have any charges pending anywhere else, ma'am?
No, Your Honor.
Mr. Mitchell?
I've got nothing regarding this. We'll just defer to you, Your Honor.
Mr. McDaniel?
I don't have anything, Your Honor. I mean, I would ask her, I guess I can ask her real quick. What's your mother's name?
Susan, Susan Ann Hutchinson. It's with the E-N. She got cremated, so, it's Susan, E-N-S-O-N, Pinfield, Alabama.
Shall I do an obituary?
No, she got cremated.
I don't have it. I was gonna just see when, they said they didn't do an obituary, so.
Well, there had to be a funeral home to do the cremation, ma'am, right?
Yes, Your Honor.
What funeral home was it?
I'm not quite sure of the funeral. I just know she's in an urn, a purple urn at my stepdad's house. I've been trying to take care of him since the passing.
Was there a service?
There was
A
no
memorial
service.
service? I'm
No,
sorry?
she just got cremated.
All right. Mr. McDaniel, I'm tempted to put her back on probation, but I'd like to verify she's not just making up a bunch of stuff. So what I'm gonna do is, having accepted her admission, I'm gonna set her sentencing for tomorrow, Mr. McDaniel. That'll give you time to look into it. And if you can verify what she said about her mother, I'd like to know the date. If she did pass away in early July, then I'm tempted to give her another shot at probation under the circumstances. So Ms. Holloman, I'm gonna see you tomorrow morning at first appearance. We'll see what the state and defense are able to find out, ma'am. So any information you can give your attorney to help you is gonna be important to see you tomorrow. Any questions, Ms. Holloman?
No, thank you.
All right, ma'am. I'll see you in the morning.
Okay.
What's her mother's name again?
Susan Ann Hutchinson, Hutchenson. She was a hollerman before.
I'll see you in the morning, ma'am. We have Ernest Walker next.
Lindsay on the case. I like this audience. You guys are always involved, looking things up, figuring things out. According to her, mom passed in January. So that's it's going to change things just a little bit. So let's try to go back to Judge Boyd. I think I've got her to the point where she's at least about to hit the unmute button. Give it just a moment. She'll cut in.
All right, did you understand by pleading true to violation of condition number 1 in 2023 CR 3543, the court could find it true, grant the motion, find you guilty, and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand by pleading true to violation number 1 in 2024 CR 4456, the court could find it true, grant the motion, and sentence you up to 1 year in the Bexar County Jail?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 1 in each cause number?
Yes, ma'am.
In each cause number, the court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is to deny the motion to adjudicate, continue on as deferred. And in the 2023 cause number 2023 CR 3543, extend for 1 year, amend for outpatient treatment program and monthly UAs. And then under the 2024 CR 4456 cause number, amend for outpatient treatment program and monthly UAs, Your Honor. And the state will take into consideration cause number 2025 PF 24726, which is the possession of the Penalty Group 2 controlled substance that he pled true to, and number 1 of each of these MTRs, Your
All
Honor.
right, so you said 2025 PF?
Yes, Your Honor. 2025 PF 26.
26, okay. Counsel, is that the agreement?
Yes, Judge.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, thank you, State. So you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So,
All right, you can lower your hand. State your name for the record.
Moses Anthony Ross.
All right, so what is your drug of choice and what have you been using?
Just marijuana.
Well, I mean, there's no just marijuana to it.
TC.
Do you want to go? Well, what I mean is, you're not allowed to use drugs while you're on probation. Do you understand?
Yes, ma'am. I, when I first started probation, I had a prescription that was approved by you.
Mhm.
That my probation officer told me it was okay.
But what is this possession about then?
It's the same, THC. It's just THC. I get it from the stores, from like the dispensaries here in San Antonio. But and then she told me that the provider that I had doesn't get accepted by you no more. So I had to find another one. And it took me about a month, but I found
Well, I
it.
mean, provider not accepted by me. What do you mean?
She said,
where he got his original prescription. It was okay the first time and it got approved by the court. It's when it needed renewing, that same place where he got the prescription was not recognized by the court anymore.
she told me I could no longer use it.
Oh, well, then there's something wrong with that provider because I'm just not,
Oh, I know.
saying, oh, you're okay now, and then this time you're not okay. So,
I mean, I understand. It's just that I don't want to call it a vendor, but for the lack of a better word, the location where he'd been getting his prescriptions was no longer recognized by the court.
all right.
She told me when it expired that you no longer take that provider, and then that there's only a certain list that this court takes, and that it took me about a month to find it. And
Well, I will tell you the certain list because people keep saying it's people that I'm not approving. There means that there's an issue with that provider.
Yes, ma'am.
It's not just me just saying, oh, no, you can't use a provider, but you can use it now, but I'm going to take it away. That means that there's an issue with that provider. There's an issue with that provider's license. There's an issue with that provider's prescriptions and what they are using, the criteria they're using to give prescriptions. So, you understand?
yes, ma'am. I got a new one.
Okay,
Yeah, the probation just showed it.
yes. So what have you done since you've been on probation?
I did my class, my first class I completed. My second class, she said I could start at the end of July of this time, and I got in trouble, so I didn't start my class.
All right.
But all I have to do is complete one more class, and I would have completed both my.
What, that's parenting?
That's the one he needed to start in July.
But she told me I could wait till the end of July since I just got done with the other probation in that class.
Right. All right, and I'm sorry, State, were you asking for an extension of 1 year
Yes, Your Honor.
and 3543?
Yes, that's what the recommendation was from probation. I believe that it's supposed to expire month, the 20, yeah, and
That's on the 2023 case.
the 2023 case, and it had already been extended once already, Judge, so.
It was
I mean,
extended
the other
once.
one, he's not expiring until 2026.
The first one got extended because of monies.
Okay,
And Judge, I think they're asking for the extension in order for him to do the outpatient treatment program, but depending on if you think that's even necessary, given that he has a prescription.
Because the outpatient treatment, I'm assuming it's because the possession of a controlled substance, which was the marijuana that he didn't have his prescription for at the time because the provider is no longer on a list of approved providers. So what I'm wondering is we just let the 3543 case expire,
Mhm.
and then he's still on probation.
The other case?
on the other case.
That's fine with the state, Your Honor.
June of 2026, Judge.
And then in the other case, he still has an affirmative finding of family violence, so it's the same.
Yes, Judge.
All right, so this is what the court will do then. In cause number 2023 CR 3543, the court is finding violation of condition number 1 true. The court will deny the motion. And that case will expire on August 24th, 2023. I'm sorry, 2025. Thank you. And then in cause number 2024 CR 4456, court is finding violation of condition number 1 true. The court will take in consideration 2025 PF 24726. All right, and then I really don't see the need for, as everybody stated, I really don't see the need for outpatient treatment or probation. Do you see the need for outpatient treatment? All right. So this is what needs to happen though. Whatever your prescription is, it's not a free pass for you to use more than you're supposed to be using. You understand?
Yes, ma'am.
And probation, I see that it's for PTSD.
The first one was for my ACL, MCL. I have full reconstruction surgery on my knee. I fractured my lower back. I'm a barber. My back hurts. My knees kill me. Both of them are torn. And my dad was in the military, so all that's documented through in the hospital.
So is it for PTSD or not?
Yes, this one is, yes, ma'am.
All right, so is there anything we need to do to address the PTSD probation? All right. All right, then those are the court's orders.
Thank you, Judge.
You need to make sure, we're off the record, you need to make sure that you complete all these programs. And even though your probation officer is telling you, well, we can start at this time, just do it, get it out of the way, complete it. You understand? Is there anything else?
Yes, Judge, as part of his bond condition, we put him on GPS partial. I don't know if we need a separate order to remove it this morning or today.
State, do you have any objection to the removal of GPS? He's on GPS.
It's part of the bond condition the judge gave a couple of weeks ago.
No, Judge. I mean, I think one of my questions was in the new case, he was out on St. Mary's buying the product, and that was just a concern. I didn't know what time that was at. I just want to make sure he's following probation rules, as in some type of curfew of not being out late.
All right, so this is what we'll do. We'll continue with partial GPS for 30 more days. Come back and we'll see how he's doing. If there are no issues, then I'll consider removal.
Okay, can I go ahead and get that court date today then?
Sure.
Miss Boyd?
Yes.
Oh, can I get it on tracking? I'm a barber. My clients book at like 9 in the morning, and I stayed till like 9 or 10. And I've been doing it for like a year, 2 years.
You need to speak to the state about that. Your attorney needs to speak to the state about that. I'll let them confer with the state. So confer with the state about that.
Judge.
You're welcome.
Have a good one.
You too.
All right, let's stay in Texas, but we will go back to Judge West.
I feel like you've been here before, right? Or no? I'm sorry? Okay. Give me just a second. It says initial, but I feel like... Did you just bond out? No? So have you already been here and I told you to go hire a lawyer and all that? You haven't done that either. Okay. All right. So I guess this is your initial appearance in cause number 25 DCCR 0532. You're charged with the state jail felony offense of injury to a child, elderly, or disabled individual, and that's from February 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Ollie, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Krishara Bennett. Okay, I knew that sounded familiar. All right, are you Krishara Bennett? And Ms. Bennett, this is your initial appearance in cause number 25 DCCR 0062. You're charged with the 3rd-degree felony offense of credit or debit card abuse, and that's from November 14th of 2024. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Bennett, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. I know you've heard this before, but nobody can ever say I didn't tell everybody. Bring me back those names so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Got lots of initials today. Derek Mouton. Good morning, sir. You're Derek Mouton?
Yes, ma'am.
And did you get someone hired, Mr. Mouton? Okay. Did you talk to some lawyers?
Yes, ma'am, I talked to you.
Who'd you talk to?
I talked to Mr. Jones, I talked to Ms. Brittany, I talked to Mr. Kevin Lane, and also I talked to Sean Sanders.
Okay. And so where are you going to be able to get someone hired, you think?
Well, I kind of already have an idea who I want to go with. It's just a matter of me just setting up, just to be able to pick one.
All right. Which one do you think?
I'm going to go with Ms. Brittany Holmes.
Okay. All right. Well, thank you for doing what I asked, Mr. Mouton. I'll reset your case about 30 days to give you some more time to try to get Ms. Holmes hired. If you get her hired between now and that next court date, bring that reset notice to her. If for some reason that's not going to work out, talk to some others. You can see that they all have different plans and payments and things like that. All right. Step in front of the clerk. She'll give you a reset notice. Eliza Riley. Good morning. You're Eliza Riley? Elisha? Okay. And Mr. Riley, did you get someone hired? Speak up, please.
I said I talked to a couple people, but I ain't getting nobody hired.
Who'd you talk to?
Burbank, Macon.
Mr. Riley, if I test you this morning, you gonna have anything in your system?
No.
Have a seat in the jury box. I'm gonna check your, have you tested first? Oh. Mr. Parker, Timothy Horace, sentencing. Good morning, sir. You're Timothy Horace. And Mr. Horace was previously in court, entered a plea of guilty to obstruction or retaliation. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, Mr. Horace, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement. Find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And if you do all of that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, your probation revoked, and you could be facing that 10-year sentence that you've agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Thank you, Judge.
Do you have anything else?
Nope.
All right.
I'm more nervous than being a judge.
I know. Be careful. Let us know. She's on her way right now. Like we're all like, oh. Let's see. Darius Sparks. Good morning, you're Darius Sparks. And Mr. Sparks, this is your initial appearance in cause number 25 DCCR 0754. You're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation, and that's from May 7th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right, so what I'm going to do, Mr. Sparks, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes.
And also, Mr. Sparks, as a condition of your bond, were you told that you're not to have any contact or communication with Ms. Gage?
Yes.
Right. Why did you pause?
Because there's a lot of stuff that transpired. We still starting.
No, you're not. Not as of today, or you're going to jail. Do you understand me? It is a condition of your bond that you have absolutely no contact and no communication with her. If I find out that you are still doing that, you will be in jail and your bond bill will be raised so that you don't get out. Do you understand? I don't care. She can't. You're following my rules now, not hers, okay? She can't give you permission to break this order, okay? When your case is all over, or we'll see what happens with your case, maybe that changes in the future. But as of now, because of what you're charged with, she can't say, it's okay, I won't tell anybody. She's still gonna be out and you're gonna be in jail if you do that. So it's temporary, potentially. You better follow that court order or you will be back in jail. Do you understand? Okay, step in front of the clerk. Mr. Green? Mr. Green, it's important that you're here on time, okay? All right, I'm going to recall that bond forfeiture. You are Ronnie Green, and this is your initial appearance in cause number 25 DCCR 0735. Give me just a second to this up. You're charged with the state jail felony offense of money laundering from March 3rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. Well, I actually gave a lawyer half of the payment already.
Okay, who's that?
Miss Holmes.
Ms. Brittany Holmes? All right, so what I'll do, Mr. Green, is reset your case about 30 days or so to give you some time to see if you can get her paid off. Bring the reset notice that you get today to her, and then she'll tell you what to do. If you're still making payments, just continue to do that. Bring me a receipt when you come back to show me that you've done that, and then I'll give you a little more time, okay? All right, step in front of the clerk. She'll give you a reset notice.
All right, let's head back to Louisiana. They're about to put another person in front of the panel of 5.
For accommodating us this morning, and we have Mr. Patterson is our case at DCI this morning. Good morning, Mr. Patterson. Would you introduce yourself to the panel? Tell us your name and DOC number.
James Patterson, DOC is 84617.
And you have counsel there with you this morning. Counsel, would you introduce yourself?
Good morning, committee. Adrienne Hutchinson, attorney to the Louisiana Parole Project, here on behalf of Mr. Ben Patterson.
Right, good morning. We also have in support Mr. Kerry Myers with the Parole Project. We'll hear from him also shortly. We have some folks here with us in Baton Rouge who are here in opposition, who want to speak, and we'll call on them at the appropriate time. We have Jennifer Solomon, Sidonia Solomon, and Drusilla Arnold. And we'll call on them at the appropriate time. First, Mr. Patterson, let me read some identifying information. You are classified as a first felony offender, currently serving a life sentence for a conviction in West Baton Rouge Parish, second-degree murder in 1977. Your parole eligibility date was August 1st of 2017. Is all that information correct, Mr. Patterson?
Right, the crime happened in 1976.
But you were sentenced in 1977.
1977, yes.
Okay. All right. So tell us about it, Mr. Patterson. You know, what happened? You know, why are you in prison, and why should we vote to release you early?
Crime happened with my girlfriend. At the time, her daddy come, I was at her house the night that it happened. Her daddy come, he tapped me on the shoulder because I was asleep and I was holding my son. He had told me to get, say, go over to the saloon, get Netta, tell her to come home and look after her baby. I said, yes, sir. Put the son down in the little playpen, walked over there and tapped Netta on the shoulder. I said, your daddy said, come home, look after the baby. I left out before work. I went back to her house, picked my little son back up. He come through the door, got in front of me, went on this little half water thing that cleaned him up and everything. I didn't say much or nothing to her. But that happened. And when she cleaned him up, she went upstairs with him, put him, laid him in the bed, took him about. I went upstairs, but I had sauce, white sauce, a knife in my hand. I went up there to ask her, come downstairs, cut me a piece of her mother's sweet potato pie. Boy, she blowed up on me. Like I say, from that point, that's when it really happened.
All right, Warden Bickham, what can you tell us about Mr. Patterson?
Good morning. He's been at TCI since 2012. So he's been here a good while. Last write-up was in 2013 for a fight. So he stays out to a lot of, as you know, he's in a wheelchair. I have a nurse practitioner here if y'all have any medical questions, but basically he doesn't, with his medical issues, he stays out of trouble, but doesn't give us any issues like that. He does a good job.
Boy, Meekum, could she give us a brief update real quick on his health?
Yes, sir, Mr. Freeman. She's coming right now.
Morning. Mr. Ben's got multiple medical problems. I assume he was transferred here due to his kidney failure and he's on dialysis. He also has some heart conditions. He's had heart attacks in the past. He has some heart irregularity in the rhythm. He's on blood thinners. He's got liver failure as well. He's just got a lot of chronic medical problems that are not going to get any better.
Thank you, ma'am.
And is he ever able to get out of the wheelchair? Is he mobile at all?
He walks a little bit, but I think it's mostly weakness that keeps him in the wheelchair most of the time.
Okay, well, thank you for being there. We're going to move and hear from Mr. Myers. Could we hear from you, please?
Yeah. Good morning, Kerry Myers with Louisiana Parole Project. We're here to let the board know that we supported Mr. Patterson as an Act 280 lifer. We supported him at his last hearing. His health has continued to decline. Since then, want to let the board know we, along with Ms. Hutchinson, we've been working with the institution to find him, should the board grant him parole, find him placement in a nursing facility. His medical conditions are beyond our capacity to manage, but we would, if he is granted and is placed in a nursing home, we will follow up to make sure he's getting the care that he needs.
Okay, thank you. Ms. Hutchinson, I'd like to hear from you.
Thank you, board. Mr. Ben comes before the committee today, remorseful and taking responsibility for the harm he's caused. He understands that he should have walked away and not let his emotions and anger get the better of him. He is abundantly aware that it was solely his actions that caused Ms. Netta's death and the devastation to her family. At the time of his crime, his life sentence allowed him with parole eligibility after 40 years, which is how he is eligible for that today. I did want to give just kind of a brief background because in his 2019 hearing, it was largely denied because of his inability to, or him not having completed enough rehabilitative programming. But as the warden explained, Mr. Ben is in the clinic 7 days a week because of his diabetes, and then 3 days a week for dialysis. So he's extremely limited in the ability to kind of go into classes. Plus, even with representation of him, he's had frequent hospital visits and things like that, that just limit his ability. Also, in 1977, when he entered into prison, rehabilitative programming as we see it today was not the same. He was a lifer, and that programming was likely not available to him until the 90s. And by then, he was a Class A trustee for prison enterprises at Angola. He worked the combines in the tractors for about 20 years, sometimes 16 hours a day. So we hope that you see that dedication within that position to show that he was disciplined, reliable, and had a strong work ethic. I just wanted the committee to just be aware of the circumstances around him not having the programming that you typically see. I did give you all a very short pages 4 to 6 in my memo going over just his chronic medical conditions, which the nurse practitioner was able to go over with you all. And it is the reason that once I began working with Mr. Ben, we realized that he would be better suited in a nursing facility So because of his severe, and multiple chronic health conditions, they've also drastically reduced his physical ability, movement, and independence, truly eliminating any possibilities of him reoffending. Today, we ask that you review his remorse, accountability, his extensive work history, his good behavior. He's had about almost half a century of incarceration. He's been, I think, 75% of his write-ups were over 20 years ago. If released, we're just asking that he be sent to a nursing facility or a healthcare facility to ensure he continues to receive the proper care. And while DCI has been amazing taking care of Mr. Patterson, I think it would be beneficial for the staff to be able to focus that attention on people who may not be able to be released because they still pose a threat to society, where Mr. Ben does not, but still requires so much care. Again, we are only seeking parole for Mr. Ben to be sent to a nursing facility as a condition. He does have the support of 3 living siblings who are watching on YouTube. However, their ages range from the late 60s to late 70s, and they are just not capable of attending to Mr. Ben's healthcare needs, but they are willing to work with us and any nursing home facility that would be available to take Mr. Ben. Thank you.
Thank you. We appreciate the information. Well, before we start our interview, we'd like to hear from the opposition. Could we hear first from Ms. Jennifer Solomon? Good morning.
I'm addressing you all because I'm saying you may have health condition, but I was there when it was happening. And the accounts of the event that he gave you all is not correct. My dad was not home that evening, but I was there and my mother was there. I had with Johnny, that was the baby. He was 10 months old. Ben literally was waiting outside the home when she came home. When she came home, she didn't even realize he had came in the house back then. She went upstairs to get ready for bed. When she got ready for bed, he literally went to our kitchen and got a knife and went upstairs. Went upstairs and started stabbing her. My mom heard, and I heard we ran upstairs. My mom literally watched her daughter die in her arms. I watched her die in my mom's arms. It's not like she could get up off of her cooling bed and come home to her family. You understand that? He told her if he couldn't have her, no one else would. That means he even took the child's mother away from the 10-month-old child. I don't feel like he deserves to come home either. It's just not fair. We just recently had a family gathering, and this young man was so excited to have a picture of him and his mom together. She didn't like to take pictures, but at this reunion, he was literally like, "That's me and my mom there. That's me and my mom there." That's the only thing he had of his mom. That's the only memory he has, because he don't remember anything else. Everything else he's learning from family. I'm sorry, I just can't. No. I can't see him coming home.
I'm sorry. Thank you, Ms. Jennifer.
Where is his son now?
He lives in the family home.
Okay.
And this young man, when it comes to his mom, he was teased. He's so full of anger about his mom that He don't even want you to bring up Patterson's name.
Yes, ma'am, thank you. Ms. Sidonia? You want to speak, Ms. Sidonia? No, ma'am. You got Ms. Drusilla?
I am the niece of Annette. She's my mom's sister, and she was like a mother to me. She worked at a daycare. I went to that daycare. Because of what happened to her, her son and I have been here. He have nightmares. He is still going through a lot. And the last thing that he would need is someone that's continually lying about what's happening to me in his ear. I initially were here before, asked about rehab, rehabilitation, and things of that nature, and I said that he have gotten it done. But until you can admit what you have done, you can't change who you are, and he's a master. She had went on with her because he was abusive. He did not want her with anyone else, and he said that he did not want to see her move on without him. He said that he hid out, he snuck into the home, he murdered her with a knife out of the kitchen. He ran in the cane field and watched the police look for him. Rehabilitation comes more than with just the paperwork saying you have rehabilitated. I would think you would have to admit to yourself the truth, what is going on, and to continually bring me here for your parole hearing and lie each time about what happened. Kind of twist the knife in my gut. I don't know if I'm expressing myself correctly. Because there's so much that is inside of me with this. Thank you.
Thank you, ma'am. You did a good job. Thank you. All right, Mr. Patterson, your case was assigned to Mr. Tillis.
Good morning, Mr. Patterson. How are you? How long have you served?
49 and a half.
I see where you're only, how many classes did you take while you were incarcerated?
Yeah, so when I got here, the DCI, the only one I took was the living in balance, I think. And I think of going home, staying home.
Do you remember what year that was? I noticed that you just started taking some classes.
Yeah, the pre-release class. I just started, like you said, I just started them 2 or 3 weeks ago.
When you were in Angola, why didn't you take some classes?
I didn't have them. What that ain't going, the classes they had, people serving life couldn't attend at that time.
I noticed your story. I read your case, and I noticed your story doesn't match up with the opposition.
Yeah. The opposition, I can say, is this, I know how they feel. Like, only thing I can say is that I'm sorry that this happened. But some of what they said wasn't true.
I heard in your statement early on, you had a knife when you were going upstairs to cut a pie or something. You had a knife with you when you went upstairs?
Yeah, I had a little white glass saucer and a knife. And I walked upstairs to ask her to come downstairs with me and go and cut me a piece of the pie. And I was gonna sit right there at the table and eat the pie.
I have no more questions.
I do. Yes, sir, I agree with Mr. Tillis. Your story does not match up with your police report even, which matches up with what the, her family was saying. It says that you were across the street watching at the bar, the White Owl Bar. Then you got up and you walked in there and you asked if she was there and you didn't see her at the time, so you went to the house. And she wasn't at the house, and I mean, it was just a block away, so you could walk back and forth. So you went back to the bar. When you went back, she was sitting at the table with a man. That's what brought you to the house. So you did see her with a man. And it is common for domestic violence victims to hear the words, if I can't have you, nobody else will. And quite often it's carried through. So you were obviously very angry about what you saw, and you went back to the house. Family was taking care of the baby, but you didn't like that. And she did come home, and you had the knife from the kitchen. And you went upstairs, and then you started stabbing her. And then later in your police statement, you said that you knew what you did, and when I did it intentionally. All of those are in the police report. Now, things do change. Your health has changed. It's changed for the worse with your age. There's no doubt about that. But what hasn't changed is the grief and the loss that this family shares from an intentional act out of anger because she found someone else. Do you have anything to say about that? With the police report saying, I mean, this was your words back then, your statement.
I would like to express that the police report is not my word, because at the night of the accident.
Wasn't an accident.
Yeah, well, the night of the crime.
Crime.
I was at Netta's house from about 7 o'clock that evening up until her daddy come in and tapped me on the shoulder because I was asleep in his chair and the baby was asleep right here in my left arm. He asked me to go over to the saloon to get
There's
Netta.
not, where, I tell you what, I've already said what I have to say. There's nothing in the police report about that, which is your statement. So I don't have any further questions.
Any questions? All right. Okay, I don't see any other questions, so, Mr. Patterson, I think we are prepared to vote. Mr. Tillis?
My vote is gonna be to deny.
Ms. Stapleton?
Denied based upon law enforcement opposition, victim opposition, and the violent nature of the crime.
Mr. Bauer?
I vote to deny. The offender still hasn't accepted full responsibility for what he did.
Mr. Freeman?
I would have voted to grant with no contact with the victims or West Baton Rouge Parish.
My vote would have is also to grant to the nursing home facility only with the support of the parole project, and also with special conditions, no contact with the family, and may not return to West Baton Rouge Parish, and reconsideration should his condition improve. However, it requires a unanimous vote today, so the outcome of today is that Mr. Patterson's parole is denied. Thank you, Warden. We're going to sign off at 9:54.
Thank you. Have a blessed day.
Denied.
So I had something I was going to say on this referencing Carissa, but you kind of sorted it out yourself. You said you'll never understand lying at these hearings. But, you know, over time, the lie becomes truth. When you think something over and over, you end up convincing yourself of that, and it changes the facts in your mind, and that's probably what happened with this guy. I kind of, I think it was Michael maybe who said it. Or no, I'm sorry. Lindsay said it. I believe that he believes it doesn't make it true, and that's just it. I think he believes it because he's, you know, for the last 274 years that he's been in there, he's probably been telling himself this story over and over all that time, and it's become the truth. So I think that's probably where he's at. Of course, I don't know him, and I'm, you know, not qualified, but it's just my opinion. Let's go back to Judge Stevens.
You now call 24 CR 692, State of Texas versus Caden Michael Brown. That's you?
Yes, sir.
All right. Do you understand what you are charged with here, sir?
Yes.
So, Peter. Peter, just so it's relevant to all I listen about. Oh. I.
Went to a few hands.
Yes, sure.
Nah, that's the song.
We've been working on this one for a minute.
Mr. Brown filed his own. Some of his motions. That was kind of getting delayed, wasn't it?
Yes, sir.
Once that, and that shouldn't happen. Right.
I'm close to 30.
Don't see any letters or infestation.
You're putting me on this one.
Yeah, but nobody put it there.
Yeah.
You put it in the file, so.
You can't even go next to the I'm looking.
You're right, just like. Temporary plan. Yeah, we lost the date on this screen.
What?
It's 8/18, isn't it?
It is.
Date on the screen, but it's quit showing all of a sudden. Wow. All right, the cart before the horse. The court calls 24 CR 692, the state of Texas versus Caden Michael Brown. That's you, sir.
Yes, sir.
Here with your attorney, Ms. Delage, Jennifer Delage, who's a fine lawyer. And you were charged in this indictment with the 3rd-degree felony of injury to another person. And I think that is a 3rd-degree felony, but tell me what the plan is here.
The intention is to
go with the lesser included offense of Class A family assault.
Okay.
There's, these two individuals had a dating relationship at the time.
Again, Class A misdemeanor.
Correct, Judge.
Is that your understanding of the agreement?
Yes.
So, intentionally cause bodily injury, a disabled person by choking. So what we're taking is disabled out.
Correct, Judge.
Okay. And so it's a third-degree felony. It's dropped down to the lesser included Class A misdemeanor of assault.
Correct, Judge.
So that means you're facing up to 1 year in the county jail and or a fine up to $4,000.
That's
Do you
correct.
understand?
Yes.
An agreement has been reached here where you would be guilty, sentenced, fine in the county jail for 1 year. Is that it?
Yes, sir.
And given credit for time served, whatever that is, you will be allowed credit for time served. This is going to run concurrently with 2 other cases.
Both misdemeanor cases.
And then is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included Class A misdemeanor of assault?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Right. What does, let me ask this family part, what does this do in this Class A misdemeanor? Or is that extracted?
Assault family, it's a Class A.
I understand, but the judgment is going to have to show family violence.
Yes, sir.
Okay.
That's to ensure that if this ever happens again, that it's treated as a felony.
And again, how do you plead to this Class A misdemeanor of assault? Guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with
Yes.
your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You are mentally competent to enter this guilty plea. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, compensation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived.
Yes, Your Honor.
I'm going to find that you are indeed pleading guilty voluntarily, knowingly, intelligently to this lesser included Class A misdemeanor of assault family violence. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this class of family assault misdemeanor. Following this agreement, you hereby sentenced to confinement in the county jail for 1 year. And this will run concurrently with other cases. You understand?
Yes.
Anything else to add on this? Okay, thank you.
Thank you very much.
All right, well, he queues up the next contestant. Let's go back to Judge Boyd.
Judge, I went ahead and filed a motion for continuance. I have a really complicated week. In the motion, you will see, in addition to the setting, which I'm in the middle of trying to get.
All right, so I know you say you filed the motion, but you'll need to get them to print it out because if you filed it by e-file, I don't have it.
Down there right now.
Okay.
But what's in the motion as well is I've been working on a manslaughter case. And we finally got a date.
Okay, so let me just tell you, I appreciate everything that you're saying, but until I see the motion, there's nothing I can do.
I'm just trying to give heads
You're-
up.
you're-
I know you are.
You're giving me a jacket cover on the book. You're like, hey, let me just tell you what's gonna happen in the jacket
I'm
cover.
transparent, Judge.
Yeah, no, I appreciate that. So once you have that before me, then I'll take it up.
I'll be right back as soon as I can get it to the judge.
All right, thank you. Sure. All right, who's here? Larry Garcia? Are there any applications in this case?
No, Your Honor.
All right, court is calling 2025 CR 007787, State versus Larry R. Garcia. Can I have parties announce?
Lauren Espinoza for the state of Texas.
Robert Gaona for the defendant.
And are you Mr. Garcia?
Correct, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the court admonishments with your attorney?
Yes, I did, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea agreement with the state, the court does not have to follow that plea. If for any reason I don't follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
All right, and probation, this is not an application. Counsel, I'm sorry, sir, did you understand you have a right to jury trial?
Yes, Your Honor.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
By entering the plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am, Your Honor.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
All right, according to the plea, the state is asking that your punishment be assessed at 108 days in the Bexar County Jail under 1244, and there's a $500 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes, Your Honor.
Did you understand it
I did.
and sign it in both places?
Yeah, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, have there been any such motions?
No, Judge.
To the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I'm guilty, Your Honor.
State any evidence?
Yes, Your Honor, state offers into evidence what has been marked as State's Exhibit 1 in all attachments.
Objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Oh, yes, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial?
Oh, yes, Your Honor.
It's a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
I understood.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I understand, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Cindy, do you need a cough drop?
I've got one in my mouth.
Okay.
Taking a sip.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Only that you accept the plea bargain we worked out with the state, give them credit for time served and judgment satisfied.
All right. The court will find you guilty as previously stated. The court will sentence you to 108 days in the Bexar County Jail under 1244. The court will give you credit for any time served. There is a $500 fine, time and money to run concurrently. Counsel, does he have exactly 108 days?
On the docket sheet, it says 107, Judge. So.
All right, so here's the thing. With regards to jail time credit, I can only give you credit for the amount of time you've served day for day. The sheriff's office, they're in charge of whether you receive 2 for 1 or 3 for 1. I'm not in charge of that. What I can tell you is I've entered a sentence of you of 108 days in the Bexar County Jail. So if you have 107 days today, maybe they'll release you today, or maybe they will say you owe them another day. That's completely up to the jail. Do you understand?
I understand, ma'am.
Now, if they keep you there past 108 days, then your attorney comes back here and we'll find out what's going on.
I understand.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to change your life. How old are you?
35.
All right, you're 35. Now, you're receiving a guilty verdict in this case. That's the easy way out for you. And you're like, hey, this is great because I want to be out of jail either today or tomorrow at midnight. Why they choose midnight? Again, that's the jail. But at the end of the day, if you have an addiction and it's addiction to heroin, that's a major issue. And unless you get help for that addiction, time you leave the Bexar County Jail, since you've been there for 107 days, probably gone through detox, what's going to end up happening is you have these plans, right? I'm never going to use again. I'm getting my life together. I'm going to get my family back in my life. And then the next thing you do, you hit freedom, you smell the air, you get involved with somebody because you're supposed to change people, places, and things. And the next thing you know, you're using. And the last time you use could be the last time you use. When you get out of jail, you know what the first thing you should do before you call family or anybody and make promises about I'm changing my life? You need to find yourself a meeting and go to a sober support meeting. You need to find yourself a transitional sober house to live in. If you cannot find any of those things, you come back here, I'll pick up the phone, call somebody to help you. But nobody can help you if you don't want to help yourself. You understand? So don't call family making promises that you're going to maintain your sobriety when you haven't been tested yet. You understand?
I understand.
All right, good luck to you, okay?
Thank you.
You're welcome.
So I'm staring at my various feeds, and yet again, they never disappoint. Another busy weekend in Clayton County, Georgia. They have a full hallway of people just jammed in there, ready to have their first appearances. So that's always fun. But let's go back to Judge Stevens' court, where he has somebody who actually showed up like they were dressed for church.
Scarpetta. Okay, hold on. It's busy.
Is it?
Gregory Scarpetta. 41314 is called. You were Gregory John Scarpetta.
That's true.
Present with Mr. Gertz, your attorney, and the state's attorney does. The defendant waive a formal reading of this indictment and the arraignment here. Can we proceed in summary?
He will, Judge, and you can.
In summary, sir, this indictment alleges that on or about March 11th, 2020, in Jefferson County, Texas, you committed the second-degree felony of manslaughter involving a motor vehicle. Do you understand what you're charged with here?
Yes, Your Honor.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement has been reached. In your case, you would be pleading guilty based on deferred or unadjudicated probation, which can be up to 10 years in length. Fined $1,000, and there will be other terms and conditions of probation. It looks like your driver's license has been suspended. Was that right?
It would be suspended as part of the agreement.
Yes, Your Honor.
A loss of life in this?
Yes, sir.
Is this there will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor. Judge, I'd like to interrupt if I could.
Go ahead.
The parties have agreed to the term of probation being 5 years. I know that Your Honor always makes that decision, but I want to announce that that is what the parties intend. I'll tell
It's the judge's call, isn't it?
It is, Judge. You can either hear out our argument later, or I can continue to tell you why we.
Go ahead.
Mr. Scarpetta has no criminal history whatsoever. This arises out of a medical condition.
I don't understand.
It was a diabetic related accident that is the result of manslaughter. The manslaughter is because this has happened on more than one occasion, the particular condition. That's what the state intended to improve as to the reckless nature. It's not, he's never caused the death before, but he's had accidents before. There is certainly a loss of life here. So the parties are recognizing that and moving forward in that regard. He has been on some form in terms of conditions of release similar to probation since the original indictment on this matter, which was back in 2020. And that's what we're taking into account in making that suggestion. And it is a joint suggestion to the court. Did I fairly state that?
I think that's perfectly accurate.
And you can see some of what I'm talking about in the terms of the indictment, Judge.
What was he using midazolam for?
It's just an anti-anxiety medication that was prescribed, Judge.
It was prescribed, yes, sir. I had it as an antidepressant.
It's benzodiazepine, right?
That's correct.
It's a form of, yes, sir.
It's a slow acting, and the amount was appropriate for the prescription.
It keeps showing that the defendant ignored the alarm beeping on his device and continued to drive his vehicle.
We believe that's the
On two separate occasions.
Yes, sir.
We agree that's the issue.
That is one of the underlying facts about the culpability, is why it rises to recklessness, Judge.
Recklessness, it arises to intentionally and knowingly.
Well,
ignoring the alarm,
I
yes,
think,
sir.
Judge, it's being aware of the existence of that circumstance and disregarding it in a way that created a risk for other people is really what
You think it killed somebody?
Yes, sir.
Judge, I'm
Okay.
sorry, I'm not
All
being
right.
sarcastic.
Well, no. I'm not being sarcastic either. Is why we have a victim who is deceased. This is the second occasion that he had an issue concerning this matter in another automobile accident.
Yes, sir.
So which was how long before?
A number of months.
Within
a few months.
Yes, sir.
A few months. So he, but he is going to admit to committing the second degree felony of manslaughter.
Yes, sir.
All right. And y'all are asking for a reduction in the probation term.
We're informing the court we've agreed to 5 years.
Okay.
Your Honor, we always know that you get to make that decision.
Okay.
I've given you our reasons.
All right.
We respect whatever you decide, Judge.
Okay. He is still eligible for release in 1/3, is he not?
He is,
And
Judge.
that's notwithstanding.
There's no
Okay.
exceptions on that.
All right. Because of my strong belief of the sanctity of life, the loss of life has its price. And I hear what y'all are saying, but I intend to follow the agreement, but he's going to be placed on 10 years probation.
Thank you, Judge.
And then he will be eligible, doing well, to release on 1/3, which I do all the time, if he does well. I'm concerned about a second event like this happening, and then you working off here on probation and driving another vehicle.
Judge, I will weigh in on that.
Yeah.
And on my research and preparation for the multiple trial settings we've had. I've been pulling medical records, and Mr. Scarpetta had a history of events that arose up until this particular incident. But the good news is that he hasn't had any incidents since. And again, I weighed all that in and making the decision that I did.
And Judge, part of the reason we're agreeing to the suspension of the driver's license is for that reason, but also, Judge, because he has not driven a vehicle since this accident. So he's had a person driving him. He does not drive himself. That will not change as part of this. And we know that would be a term and condition of probation.
What, at the time of this event, was he under any kind of court order?
No, Judge.
No.
Okay.
And he had actually been through a review by the medical board with DPS in relationship to a separate incident, was given back his license, and I took exception to that, which is why I've been pushing the issue about the driver's license.
But it's also the difference between a manslaughter and a homicide. We think.
So again, Judge, I'm just letting you know, we have, Mr. Gertz and I have beat each other up about this incident pretty much for the last 5 years.
So who we got signed that?
All right, it's time to resolve it.
Yes, Judge, we're.
All right, in 23-41314, your Gregory John Scarpetta, with your attorney and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment here. Can we proceed in summary?
He does, and we can.
In summary, this indictment alleges that on or about March 11th, 2020 in Jefferson County, Texas, you committed the second-degree felony of manslaughter. Do you understand what you were charged with?
Yes, sir.
If convicted of this, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached between the parties where you will be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fined $1,000. The driver's license would be suspended. What's the restitution on this? Is there, there's a loss of life here.
There is,
There's
but
gotta be.
I've never been given a figure of restitution, Judge.
And I believe.
Well, it's for the probation to determine because if there's restitution.
That'll give me one more chance to get with the victim's family to ensure that there's not additional restitution, Judge.
It may be insurances, other forms of payment have been made. But the court is, if there is restitution that is owed, we're going to have a hearing on that so the court can resolve it.
Yes, sir.
Unless all the parties agree.
Yes, sir.
And that will be included in this judgment if it is applicable.
We understand.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of
Yes,
this
sir.
manslaughter? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
We have no objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with in the indictment. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the records, without objection.
We have no objections, Judge.
I'm going to follow this agreement with nothing further and find you are pleading guilty today to this second-degree felony of manslaughter voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. If you do well, it can be shortened to 1/3 of that, 3 1/3 years.
Understood.
There will be terms and conditions of probation, which are not only normal and customary, but special for this particular offense circumstance. You will be fined $1,000. Your driver's license will be suspended until otherwise ordered by the court. Restitution. The court finds restitution is an issue in this case, which if restitution is owed, shall be paid. I will have a hearing on that if it's deemed that there needs to be a specific amount. I'm going to order restitution if not otherwise reimbursed to the victim in this matter, and that's done in every case where there's a loss like this. But I don't think we're ready to determine, but I think all the parties agree if there is, it's normal and customarily part of a probation term. There will be other terms and conditions of probation, which the probation or officer will review with you. Please follow them. If you fail, your probation can be revoked, can be found guilty and sentenced up to 20 years in prison. Do you understand what has happened today, sir?
Yes, sir.
Any questions of me, or do you understand fully? Okay.
Yes.
Tragic event.
Yes, sir.
What have you done to ensure that this won't happen again?
Many things.
Yes, sir.
The most important is carrying a higher blood glucose level
Yes, sir.
and monitoring and maintaining.
Okay.
I did have a pump malfunction on one individual pump. We're since have moved to a different manufacturer and it's
working better.
flawlessly.
Okay.
For the last 4.5 years.
Okay. Please see the probation officer. Thank you. Oh, he needs your print. Real quick. Thank you. I have Braylon Oliver.
So that was a very interesting hearing. I have thoughts on it, but I'm going to reserve them because this could very well be a topic for sidebar tomorrow, 8 p.m. Eastern, 5 p.m. Pacific. I'm not saying we will talk about it, but I think we'll talk about talking about it. But I have one big question. I know that Bailey is livid, probably blew a couple of blood vessels in his noggin. Michael isn't overly happy, but I need more information is kind of where I'm at. But if we talk about it on sidebar, we'll get into it. Let's stay in Texas. We'll go back to Judge Boyd.
Is calling 2025 CR 008-182 State versus J. David Taylor. Could I have parties announced?
Lauren Espinoza for the state of Texas.
James Seeloff for the defense.
And are you Mr. Taylor?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Taylor, did you review the application for deferred adjudication with your attorney?
Yes, you know the difference. Yes.
This is the document that says that you want court to consider you placing you on community supervision or probation.
Right.
Did you review that with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment that tells what you're charged with?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Taylor, did you review the admonishments that tells you what you're charged with, what your plea bargain agreement is, and what rights you have? Did you review that with your attorney? Did you understand it?
Yes, ma'am.
You're charged with the offense of robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, thoroughly.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They'll take in consideration 2025 CR 008-183, and there's to be restitution, if any, to the Dollar General store. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's our plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the Dollar General and with Erica Aguilar. Did you understand that to be recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers what has been marked as State's Exhibit 1 in all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, and we waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, the item that was taken in the store was returned to the store. So as far as restitution, there is none. And there's a TIC of the evading arrest, Your Honor, as part of the plea bargain. And I just got the motion for dismissal. My client, whereas he is homeless at the current time, he does have employment opportunity through the nursing industry. Is that correct?
Oh, I don't allow that. While you're on while you're on probation and felony probation in this court, I don't allow people to work as home health care providers,
Healthcare.
minors,
It's
nursing.
triage for like a call center.
When you say triage for a call center, what do you mean?
It's like people would call in from various companies and then we do the triage before they are transferred to nurses.
So
On the phone?
Right.
what is, I've never heard of
Like,
triage on the phone. What are you, a 911?
Right, somebody would call in like they have a medical emergency and then we kind of type up whatever the issue is and transfer either to.
All right, who's allowing you to do that?
It's a job opportunity that I have. I've worked at CareNet before, so it's still an open opportunity to go back.
Well, why were you homeless?
I went through an eviction process after the death of my father and kind of just hard financial times.
He's one credit away from associate degree. Is that correct? Through SAC and Northwest Vista. That's how much education he has.
Okay.
And that's why we're pleading for or wanting deferred adjudication in this case, because he's got that opportunity and even at his age, he may consider the armed services and they will not allow him.
Well, how old are you?
36 currently.
And you told me Marine Corps will take you up to 40?
So
Well, why wasn't this done before all of this happened?
Just mostly, I was trying to obtain my documents after, the eviction. I lost like a lot of my, paperwork and most of my home, so it's been a very difficult couple of years, rehabilitating.
All right, is there any drug issues with you?
No,
Do you have any children?
no.
All right, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the Dollar General stores, although that my understanding, they no longer have anything that costs $1. There's to be no contact with Erica Aguilar, that's Erica with a K. 200 hours of community service restitution. And I'm going to order the theft course. Once he completes the theft course, the community service hours will be deemed satisfied. There's to be field visits 1 time per month for 4 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just understanding that I do apologize for,
No, I want you to understand what's going on.
I do understand, but I want to just apologize. And I guess I was kind of just in a desperate position, but the time I spent at Bear County, these 4 months, I gained a clear mind. So I realized it's not a appropriate course of action and that there's other alternatives.
Yes, and here's the thing. I understand when people go through different things, but we do have laws, right? And I understand that the item that you stole, was Clorox wipes. But when you take an item and then you make physical contact with someone and you're taking that item without permission, that's when it becomes a robbery. And you're looking at 2 to 20 years. And a lot of times people will look at it and they will just say, oh, it's only $10. Oh, it's only $5. That's the range of punishment for robbery. And in the penal code, that's what a robbery is. You understand?
Yes, ma'am.
I represented someone before and they were on parole. And they were on parole during a life sentence. I didn't represent them, for their trial court matter. I was just representing them for their parole. And you know what they were doing a life sentence for? Stealing, the little metal piece that you have on a water hose that you screw in to the faucet. That's what they stole. What is that, $2? And they're doing a life sentence. Yes. So you got to make better decisions. Otherwise, you're going to be looking at yourself, maybe being a repeater or a habitual. The fact that we're homeless, the fact that things haven't gone our way doesn't give us an excuse to steal. You understand?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes.
you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you in this court. In order to be successful, communication is key. If there are issues, you need to let your probation officer know about it. If you feel that they're not addressing it, you can always approach the court. Do you understand?
Yes, ma'am.
All right, good luck to you. Probation will go over conditions with you.
Thank you. God bless.
Oh, God bless you too.
Okay, we got a couple minutes left. Let's go to Miami-Dade, check in on Judge Grumpy Pants. She is working through lunch, so let's see how well this is working out for her.
That's a witness.
So the witness prevented him from making full entry into the home. She attempted to block him, body block him from fully entering the home. So it looks like there's probable cause. It's not charged as a burglary with an assault or battery, just a burglary to an occupied.
Trespass?
No, when you're taking off a
Crime
window
written?
screen, the stealthy entry, it's a burglary.
Judge, what's the crime they're in?
I don't know. He's trying to enter.
That's what you need in order to have a burglary.
State.
To commit a crime therein.
Well, there's a criminal mischief for removing the screen.
It doesn't say anything was damaged.
It's still dark out at the time he's trying to get into her home and she's scared. I think that
Actually, you know what? He admitted to getting into an altercation with the witness while trying to enter the home. It's maybe a burglary with an assault or battery. Do you want to call up the officer to find out?
He did the burglary.
Why? It may be a PBL F1. If he entered the home and he battered the victim, which it looks like the victim used her, the witness used her body to block it. The offender admitted, let's see. Oh, he said he wanted to speak with the victim. Why why didn't he knock at the front door at 4:59 in the morning? I don't know. He admitted to ripping out the bedroom side window screen, so obviously there's damage there. And he had an altercation with the witness while trying to enter the home. It said, it's your case, State.
I'm not gonna ask for the hearing.
Okay. There's probable cause for burglary to an occupied dwelling. You didn't give me the witness's name? I just have a victim.
Yes.
Okay. You're ordered to stay away from, 1 minute. Stay away from Paula Solano Serpas, the alleged victim. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
Yes.
Setting a bond, $7,500, stay away from the victim. Next is Daniel Sariba Constant, age 15.
He has to hold for immigration, Your Honor.
Okay. Good after, with Mr. Constant. Can we line him up, please, to bring him in? Get in ground seats. Good afternoon, sir. You were arrested for a felony battery. It's a case from August 10th of 2025.
Buenas tardes, señor. Usted fue arrestado por una agresión a nivel del delito grave del caso del 2021.
I will appoint the public defender's office for you.
Yo voy a asignar un abogado de oficio para que lo represente.
There's probable cause for the charge.
Y existe motivo fundado para este cargo.
Sir, you are ordered to stay away from the alleged victim, Alejandro Sarabia.
Señor, se le ordena que se aleje de la víctima Alejandro Sarabia.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No contacto con la víctima ni directo, ni indirectamente, ni en persona, ni por escrito, ni por teléfono, ni por medio de terceras personas.
No contact with the victim through social media or other electronic means.
No contacto con la víctima ni por redes sociales, ni por ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Y debe de alejarse por lo menos a 500 pies de distancia de la víctima. La casa, la escuela y el lugar de su empleo, todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucre en ninguna actividad criminal o delictiva, ni use ningún tipo de drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No use ni posea ni porte ningún tipo de armas de fuego, ni pistolas, rifles, ni ningún tipo de municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe de inmediatamente entregar al departamento de policía sus armas de fuego, municiones o algún tipo de permiso para portar armas o armas ocultas.
You may return to the victim's residence one time only within 48 hours of your release from jail.
Y tiene que entregar ese recibo al tribunal. Y puede regresar a la casa de la víctima en espacio de 48 horas después de que lo pongan en libertad de la cárcel.
You may return, you must be accompanied by a police officer when you return to your residence.
Y tiene que ser acompañado de un oficial de la policía cuando usted regrese a su casa.
So that you can retrieve your personal clothing, health items, medication, personal and business related paperwork and work tools.
Para que pueda obtener, sacar de ahí sus efectos personales, sus papeles de negocio importantes de medicamentos o herramientas de trabajo.
If you go to the victim's home without the police, or if you stay there, you will be arrested.
Si usted va a la casa de la víctima o se queda o permanece ahí, y usted será arrestado.
Do you understand the stay away order?
¿Entiende usted lo que significa la orden de alejamiento?
Sí.
All right,
No
sir, you have it.
contacto. Yes.
Yes.
Thank you, sir.
Yes.
You also have an
Gracias,
immigration hold. Your bond is
Usted también.
$5,000. Have a nice day.
Usted también tiene orden de inmigración para mantenerlo retenido y su fianza es de $5,000.
Okay, thank you.
Okay, friends, time to leave it for today. I hope you had fun. I know I did. Again, apologies to those who were on the pre-show for our little technical snafu. I had a good story from the news to share with you, but we'll do that tomorrow. But we made it through these 3 hours without an issue, but it seems like a lot of the courts had issues today. So, yeah, Tech Trouble Monday, I suppose. We'll see you all tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. In the meantime, go have yourselves a great day, and I look forward to seeing you tomorrow. Take care. God bless.